But thank you very much indeed for including me in tonight's event. I do congratulate the organisers from the UNSW School of Public Health and Community Medicine and the Public Health Association of Australia for organising this event, because it is such a vital question for contemporary Australia, and I very much appreciate the opportunity to talk to you just a little bit about our work. Here in this wonderful UNSW hall, may I also acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. I'm particularly keen to talk to groups of this kind because one thing I have learned in this job is that it's one thing to know what the law is, but it's quite another to know how that law might apply to the facts. And in our inquiry, we have included professionals, one of whom you'll be hearing from tonight, but from the medical profession, who can look at the condition of those held in detention with an objective and professional eye to help us to produce accurate and balanced information. Because as I'm sure you'll understand, we can't make statements about the physical and mental health of the inmates of detention centres. We have to rely on the professionalism of the medical service providers, and so that really does underpin this inquiry that we've been talking about. So I'd like to begin just with a few facts, just to be clear about the dimensions of what we're discussing, because the number of people in closed immigration detention remains alarmingly high today. At the moment, there are about 4,484 people in immigration detention facilities in Australia, and that includes about 3,000 on the mainland Australia and over 1,500 on immigration detention on Christmas Island, and that includes 895 children. Now, I know that we've heard in the news as of yesterday the report that Robert Cornell has made into the conditions in Manus Island and the death of one asylum seeker, and there has been an enormous media attention upon Manus Island and Nauru, as indeed there should be. But one needs to perhaps also think about the 4,500 people who remain in closed detention, including, as I say, nearly 900 children. There are 2,500 people in offshore processing centres, so-called, held on Nauru and Manus Island, with 179 children on Nauru in those conditions. People who are held in detention are particularly vulnerable to violations of their human rights. And that, of course, is where the Australian Human Rights Commission comes in, because we're lawyers, we're given the task of holding the government to account for complying with the international human rights treaties to which Australia has been such an active and willing and enthusiastic party historically. There are particular challenges to the human rights in relation to children, partly because they have unique developmental rights, and partly, of course, because they have special legal rights under the Convention in relation to children. A key concern, inevitably, is the detrimental impact that long periods of detention, especially in a harsh environment, in a remote location without adequate access to services and support, can have on the mental health of those who've been detained. In my role as president, I've been to all of the detention centres across Australia where children are held. The reality of life in these detention centres is very confronting, especially when those caught up in it are children. And I thought I might give you, if I may, a very personal example. I am a lawyer, I love the law, and I'm very happy to talk about various provisions of the treaties and how they apply under the Migration Act. But I have learned in this job that what really has an impact is to understand the impact on human beings. And I know for many of you as medical service providers, you will understand that very well. But this is a case of an 11-year-old girl, let's call her Roma, whom I met in a detention centre. She had fled from serious conflict in her home country in the Horn of Africa, and she'd been on Christmas Island for 8 months. and she remained quite composed as she told me how her brother had been killed in front of her. She remained composed as she recounted how scared she was of the waves and the sharks in the water as she made the perilous boat journey to Australia. She remained composed as she showed me the sores on her arms that won't heal in the tropical heat, and her bloodshot eyes caused by the phosphate dust on the island. It was only when Roma told me that during her 8 months on Christmas Island, she'd spent just 2 weeks at the local school, and that was essentially a playgroup, that she finally broke down in tears. She knows that to be deprived of an education while in detention is to take away not only her liberty, but her chances for a fulfilled life in the future. And it was that story, I think, that for me is the reverberating story, even though, of course, I have to be concerned about what this means as a matter of law and, of course, of justice. Well, I might take a moment, if I may, to tell you a little bit about how and why we started the National Inquiry into Children, because sadly, we've done all this before. After the Tampers case, you know, we had the offshore solution in Nauru, and the Human Rights Commission, more than 10 years ago, produced a very comprehensive report on the impact of detention upon children in immigration detention where they're asylum seekers. And that report that was handed down in 2004 led to, and we don't claim exclusive responsibility for this, of course, but at least it encouraged the Howard government to release almost all the children within weeks, and all of them by nearly 2 years later. But within a very short space of time, the children were out, and that was when the Howard government introduced the concept of community detention and bridging visas. But you all know that we're now looking at a serious increase in the deterioration of children as asylum seekers, with, as I've said, nearly 900 in closed detention in Australia or Christmas Island, quite outside from those held offshore. So it was a matter of some delicacy as to whether or not we would call this inquiry, because the numbers peaked, as you might recall, in about July last year, when the number of children in detention reached 3,000. However, as we'd moved so close towards an election, we were pretty much in caretaker mode. It really wasn't possible to call the inquiry last year. It also became very clear within a few months of the new government being in power that the level of information that had previously been available to the Human Rights Commission was now no longer available, nor indeed, I might add, much more importantly, was it available to the public. So we weren't getting accurate information as to how, why and how children were being detained. And so in those circumstances, in about February this year, we decided that we would hold an inquiry, and I have now been to 5 detention centres, along with my colleagues both from the Commission and colleagues from the medical profession. We will also hold public hearings. We've held one, and we're about to hold another in Melbourne, but we are very grateful for receiving any submissions that you might care to make. We've done a lot of interviews, we've done a lot of focus groups, and we've also spent a lot of time with children, interviewing the children with the parents' consent, and asking them, among other things, to draw pictures about their lives. And one of the very sad things is that the children draw us pictures of their lives behind bars, and when they put their identification on the picture, they put their boat number and not their name, which is a very sad phenomenon. Some of you, of course, will be primarily interested in the offshore program to Nauru and Manus Island, and I'm often asked about why I haven't yet been to either. And the answer is one that really lies in the law, and that is that Australian law does not typically have an extraterritorial effect, so my powers do not extend to Nauru and Manus Island. However, I have made the decision that because, and this is a technical legal point, but it's a powerful one, because Australia is at international law legally responsible for all the extraterritorial acts over which it has effective control, I retain the power to hear complaints from Manus and Nauru. And that gives me the power to look at the conditions of the children and to consider complaints either by the children or most particularly by their parents. So that is why you will perhaps see a rather puzzling variation in what I can do. I can't go to Nauru and Manus without the consent of a sovereign country, which I do not have, but I can take formal complaints from those asylum seekers held there. Well, we are concerned, of course, about the human rights in terms of treaty obligations, and I think you'll all be very well aware that the Refugees Convention and the principles of customary international law have requirements that a person persecuted may not be refooled or returned to the place of persecution, and that we also have obligations to assess the claim to asylum seeker status and to have proper rule of law based procedures for considering those claims. One of the most distressing aspects of our onshore position is that for well over a year and a half in many cases, the 25 or so thousand asylum seekers currently in Australia have had their claims have not been assessed. And as I say, 4,500 of those are held in closed detention with no access to the courts and no capacity whatever to have the rightness of their detention considered by the courts. That is an extraordinary phenomenon. I think most of you would think, well, what about habeas corpus? What about the Magna Carta? These are principles which sadly have been overridden by parliamentary processes through the Migration Act itself. So sadly, as a matter of domestic law, where Parliament passes a law that is clear and unambiguous in allowing the detention in these circumstances, that will trump any other fundamental freedom or right that would otherwise exist as a matter of law. So it's a very puzzling situation from the point of view of most of us who take some of these human rights for granted. We mustn't, however, in thinking domestically, forget the growing international concern, and this is something that I think we all need to be aware of. The international community is giving greater scrutiny to the position of asylum seekers and refugees. And when I was in Geneva recently, I was there when the High Commissioner for Human Rights, Navi Pillay, gave a speech to the Human Rights Council for the United Nations, the peak body, in which she called for some review of Australia's policies in relation to asylum seekers, particularly those offshore processing arrangements. Now, I mention this because it is very rare indeed for a Western developed country ever to be mentioned critically by the United Nations High Commissioner for Human Rights. And to do so before the Human Rights Council was extraordinary, very unusual. And we were specifically named and targeted in that report. And we were in the same paragraph as human rights breaches by the Ukraine, North Korea, Sri Lanka, and Syria, which gives you some idea of the egregious nature, at least in the perception of the international community. Some of you will also be aware that the United Nations Human Rights Committee has made a ruling that the detention indefinitely of those who have already been adjudged as refugees, but who have a non-appealable negative ASIO assessment, that constitutes a breach of the international human right against arbitrary detention. But it's also, and I've never seen this before in these sorts of cases, the Human Rights Committee went so far as to say that to detain indefinitely in these circumstances with no right of access to the courts was in and of itself a form of cruel and unusual punishment. That is absolutely exceptional, and that those findings and recommendations by the UN Human Rights Committee, which administers the International Covenant on Civil and Political Rights, has been ignored, and the 2-month period within which Australia was to respond has also gone by without appropriate response. And the last point I wanted to make is that UNHCR, again, the United Nations High Commissioner for Human Rights, Navi Pillay, appointed a special rapporteur for to consider arbitrary detention and to consider in particular the position in Nauru, and he was denied permission to go there. Now, to do that as a snub, effectively, to the United Nations High Commissioner for Human Rights, Navi Pillay, to say nothing, of course, of the rapporteur himself, is a very serious action, and one which I think will not go unnoticed in the United Nations context. What is it that the Human Rights Commission wants? Well, first and foremost, what we want is to see asylum seekers have their claims to refugee status assessed. That's an absolutely fundamental principle of international law that I don't think any country, except occasionally Australia, refutes. And we know statistically and in the past that 90% of asylum seekers whose claims have been assessed have proved to be refugees. We therefore believe that it's absolutely fundamental that those claims be assessed according to a proper rule of law process, subject to proper impartial tribunals to assess the accuracy or otherwise of those assessments. None of that, of course, is happening at the moment. But we're also asking, and it's somewhat controversial, that people be released, that detainees being held in closed detention be released into the community. Whether in community detention or on bridging visas, we don't really care now quite what the terms and conditions are, although we're deeply opposed to the idea of bridging visas that have no work rights, because that simply diminishes their capacity to survive in a healthy way in the future. But our deepest concern, and we have to take these things in bite-sized pieces, if you like, our deepest concern lies with the ever-extended period of detention of children in closed detention. The medical evidence is now growing stronger and stronger that the longer, and it's obvious of course, the longer you detain a child or a child's family, the more more their mental health is at risk. But there are other more physical consequences as well, but I'm sure you're a better judge of that than I. So we see that on the department's own statistics, children are now being held in detention for longer than has ever been the case before, in closed detention. And that, I think, should be something that starts to move the hearts and minds of Australians. And so in concluding, I deeply appreciate the fact that you've organised this meeting, and I do hope that from your medical services perspective, public health perspective, you can use your own advocacy to speak out about the conditions of asylum seekers in detention. Thank you all very much.